Indeed, and all the surrounding streets as well.
Wow.
Your Honor, we're on the record.
Thank you very much, Madam Monitor. Good morning and welcome to the Supreme Court. We have one matter on today's calendar, and I hope I'm pronouncing the name correctly. State versus Colthurst. Do I have that right or about right?
Yes, about right. Jamal Colthurst. Yes.
Thank you very much. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Counsel for the appellant, please identify yourself on the record and let me know how much time you wish for rebuttal.
Yes, good morning, Your Honor. My name is Michael Brown, and I'd like to reserve 8 minutes for my rebuttal.
Thank you, Attorney Brown. Senior Associate Justice McDonald will be our timekeeper, and he has some signs that will show you 5 minutes, 3 minutes, 1 minute, and your time is up. Can you see him?
Yes.
Thank you. So whenever you're ready, counsel.
Thank you. Good morning, Your Honors. May it please the court. As I said, my name is Michael Brown, and I represent the defendant, appellant Jamal Colthurst. This court has taken time to think and to write about issues of juvenile sentencing again and again. This court's decisions have been detailed, thoroughly reasoned, and comprehensive. I think perhaps one of the reasons this court keeps returning to these issues is that because they are so difficult for a number of reasons. They pull us in different directions. Of course, we don't see these types of sentences imposed on children if the crimes aren't tragic and brutal and terrible. But these crimes are committed by children, and we know children are different. But precisely because of that tension, and it's so very hard yet so very important to get these cases right, it's a difficult task to ask a trial court or a prosecutor to encompass lofty principles in a sentencing decisions that involve such brutal and tragic crimes. That's why these courts need rules, they need guidance, they need structure. The legislature provided that framework for courts to follow. We ask this court to continue to flesh out the details of that framework. And the ultimate purpose of 5491G, in our view, can be understood as a mechanism for trial courts and reviewing courts to reliably sort between those children that are deserving of those incredibly harsh sentences and those that are not. And youth, to some degree, must always counsel against the conclusion that a child is deserving of such a harsh sentence, under which it is likely they will die in prison. As a bit of a roadmap, I see Justice Keller. Sorry, I'll jump right to the questions, please.
Thank you, Justice Keller.
Thank you, Chief. Good morning, Attorney Brown.
Good morning.
I have two what I think are rather big questions.
Sure.
Your main argument seems to be that the applicability of 5491G is that the court has to presume that the youth or child was is deserving of some kind of mitigating considerations, and that the statute goes beyond what its language says, which is to just consider the youthful factors. Now, let me finish. Okay.
Yes.
My problem with your particular client is that 5491G says, in the case of a child as defined in section 46B 120, who is transferred to the regular criminal docket pursuant to 46B 127 and convicted of a class A or B felony. When your client committed this crime, we didn't have raised the age. He was not a juvenile. He was never transferred to the regular criminal docket. He was just tried immediately as an adult. I'm assuming he didn't really get any consideration for a youthful offender treatment. But how is the statute applicable to him when this statute seems to apply only to children who are transferred from the juvenile to the criminal docket?
I'm going to be frank and suggest I don't think that issue has been raised or frankly thought about. I would say my assumption reading the statute is anytime, I guess my focus has been on a child that's convicted of a class A or B felony that comes before a sentencing court after October 2015 falls under the purview of this statute.
It doesn't say that. And we have 12Z, and we're bound to apply the plain language of the statute. And this seems to me to only refer to children who are transferred from the juvenile docket to the criminal docket. And that did not happen to your client. My second question is this. The other statute applies to anyone who was under 18 when they committed their offense, okay? So that I'm pretty clear, I think clearly applies to your client. And this is my question. Judge Dewey imposed a consecutive sentence and said, well, he's eligible for parole, but he's only eligible for parole in the first 30 years under the New Britain sentence. And so how could she put a consecutive, in other words, if he comes up for parole in the first 30 years under the New Britain sentence, okay, he still has this case hanging over him. So how could they consider him for parole under the New Britain sentence when he still has this one to serve consecutively? And that's where I think the trial court may have gone wrong, because I think the other statute, 5418, is that it? The other statute says that anyone who was 18 or under 18 when they committed the crime has to become eligible for parole in your client's case within 30 years. And if he's, how can he be eligible for parole within the first 30 years of serving these consecutive sentences unless Judge Dewey also made this sentence concurrent?
Again, I'll confess to
Shouldn't she
being.
have made it concurrent so that he would be eligible for parole within the first 30 years? Because otherwise he's going to be dead before he's eligible for parole in this case, because it's consecutive.
So again, I will confess to being a little bit just thinking about this case a little differently than Your Honor is. And I do know that for whatever, and I can't give more of an explanation than to say that if you look at what parole is proliferated, I think they have an understanding that he goes to parole after 30 years effective. And
I don't understand how they can do that when he's got a consecutive sentence.
Sure. I think that even if it's consecutive, my understanding is parole would say, they would aggregate for purposes of 54-125 AF, the total effective of 165, and say that's a sentence over 50 years, therefore he goes after 30 years. I don't know their statutory, how they get to that, but I think that is the understanding.
All right, well, maybe your opponent can maybe explain. So he gets a 30 years anyway. Why does the court have to see this? So why do we need a resentencing if he's going to get a parole consideration after he serves 30 years on both of these consecutive sentences?
Well, I think that is a.
Well, if 5491G doesn't apply, then we don't need a motion to correct an illegal sentence, because, as you just said, probation is going to give him a parole hearing after 30 years, no matter what.
So, again, I will return to the first point of just not thinking through, it wasn't in my mind, that first piece about, and I guess I'd have to reflect a little bit on the answer to that. But the second piece about the parole eligibility and what you need this case, I think that there is a dispute that I have with the state that is fleshed out in the brief some about the distinction between what the legislature did with 1584 versus what they could have done given the guidance that this court afterwards gave about sort of the requirements of Miller and Graham in those cases. The legislature at the time that they passed this act had before them Riley 1, Cassiano, and Miller. And they took from that sort of the guidance of they wanted to have this sort of two-stranded approach to measuring culpability through 5491G. And then on the second piece, the parole opportunity. And I think the fact that they did both those things at the same time in the same act is important. If the parole eligibility factor eliminates what 5491G says, I think the effect of that would be that the legislature on the same day abolished an act that they created with 1584. So I think looking at what they created was they wanted this sort of two-track approach to determining the appropriate sentence. And I think the only way
they did was say the court had to consider the juvenile science. They didn't say it shall be a mitigating factor. They could have changed the penalties. They could have said that in the event of a child who's under 18 the maximum will be this instead, or it shall be a mitigating factor and the court needs to take it into account. I mean, the problem here is the sentences can be so high with multiple crimes, including murder, that some of the judges that sentence these people think that 70 years is a gift. Do you know what I'm saying?
I do understand that, and so I think I want to try to address the issue of consider, and I think there is a question of what it means to consider something, and I think the English language candidly has different meanings to the word consider. Does it mean to acknowledge or have awareness of something, as the state does argue, or does it mean something more substantive like weighing or reflecting upon? And I would say if it just means to think about and sort of, and I don't want to be flip, but in a ceremonial fashion to have just an awareness, then really 5491G is almost, the legislature has done nothing, because I think it's always been the law that a sentencing court should encompass relevant information into a sentencing decision. So I think what it means to consider is something a little bit more than to just think about. And I think it means to give these factors real weight and to take them where they lead you, which is, if you're saying on the record that these conclusions about what applies and what gives weight or gives, back up a little bit. If looking at what Judge Dewey did, she said she was accepting certain things, and then she didn't give a reason for why she would have made a finding other than, and going back, I think she did make a finding of non-incorrigibility, but I think consider under the statute means that you have to actually give them weight, and there has to be a matchup between the input of what you're saying you're considering and the output of the sentence you're imposing. And that's where we kind of, I think, get to what's something like a presumption, which I would maybe modify into, say, a sorting operation as opposed to an express presumption, but I think it gets us to a similar place. And I think I've hopefully answered your question somewhat. Justice Khan, sorry, I know your hand was up for a while. I apologize.
It's quite okay, counsel, with the chief's permission. Chief.
Hang on.
Oh, I'm sorry.
Please.
I'm just looking at the hands. I apologize.
No. I just need to know whether Justice Keller is through with her question first.
Sorry.
Thank you.
Yeah, I'm all set. Thank you. Thank you, Chief.
Thank you, Justice Khan.
Thank you, Chief. And counsel, just so you know, we try not to, it's great that you noticed our hands going up. We appreciate that. But we always wait for the chief to let us know. But thank you for noticing and stopping. Yes. We appreciate it. My question is this. In your brief, you argue that the appellate court did not review adequately whether the trial court adequately considered the youthfulness or the science around the juvenile brain. So in our cases, we try to give guidance, right, to trial judges and to the appellate court. So what I'm struggling with is, what is the proper test for adequate consideration of this factor, right? A sentencing court considers many things. What is that? Is that a number? Does that mean 80 is never adequate? Is it a moving target? Is it only the outcome? That's, I guess, what I'm struggling. If a court takes testimony about the brain development, if the court considers what, now going back, which is interesting, right? The court has to sort of go back and look at your client and how he would have presented back at the time of sentencing, or more importantly, at the time the offense was committed. When a court takes testimony about brain development and the age of your client and what that would have meant in terms of his brain and in terms of how he himself developmentally processed information, if that's not adequate and the court affirmatively saying, I'm considering this, then what is adequate? And what kind of guidance do we give courts? And if it's just the number, is that your position? Like if it's over 50, over 40, it's never adequate? Do you see what I mean? What's the test?
I do, and I will confess that I think that that's a big thing to sort of struggle with and answering, in kind of saying what the law should be. But I think if you're under A2, where a judge is considering giving a sentence under which it's likely a child will die in prison, I think we can say that number, based on prior decisions of this court, is probably 60, but I'm not 100% sure, but I think 60. I know Cassiano talks about 50, but that's not actual death in prison. That's a lot. So say the number is 60. And if the court gets to a place where it's saying, I'm considering entertaining that sentence, and then decides to impose that sentence, I think at a minimum, there needs to be a justification why this is a case where it's appropriate to override what applies for every juvenile.
So you're saying that 60, you would define any sentence above 60 as not being adequate consideration of the juvenile, the youthfulness in juvenile brain, but that could be overcome. That presumption could be overcome with some affirmative statement why, in this case, in the particular case, it wouldn't matter. Here's my thing. My recollection, and I could be wrong on this, is that Riley, when resentenced, was given 75 years. And so presumably in that case, 75 years, because as far as I know, that wasn't reappealed. Now, it may be that he didn't reappeal it. He didn't have you for a lawyer to say 60 would have been the magic number. But then it seems to me that sentences are, there may be a case where somebody doesn't deserve 60, deserves only 50. And so if we put a number, no juvenile should ever receive a sentence that's above 60 without some steps. I don't know. Who are we to put that? Sentences are very individualized. There are many factors that go into sentencing. So I don't know. So I guess you've answered my question. That in your view, there should be a number like 60. And I don't know how that plays into the idea that we do have a statutory mechanism that allows for parole hearings, which I think in some ways probably consider more factors than a resentencing, right? At a resentencing, the court's only looking at your client and what happened and his mind at the time, is not looking at what has he done since? How has he shown that his brain is now matured and developed where he's going to make better choices? So wouldn't a parole hearing and the eligibility for parole, if in fact he has it, notwithstanding consecutive sentences in different files, wouldn't that be the better route to consider this? So
I don't know about better, but I think it is two things that the legislature's done. And I think it does make sense as a framework, especially in light of what was said in Riley 1, which, as an aside, I actually was Riley's attorney on his second appeal, and we were not successful. But I think looking at what the legislature did, and if you look at Miller and Riley about those two strands, where there's one piece where you measure culpability, which is sort of the sentencing function, and you weigh all these juvenile factors and all those things, kind of looking at the time of the crime and then say that down the road there could be this other opportunity to look at the rehabilitative function. I think it makes sense that the legislature would want both those things to be done. And again, in Delgado and Montgomery, it maybe was said that they didn't need to do those things, but they did do it with 1584, and they haven't gone back and said, oh, we now know we don't need this extra sentencing structure, so we're going to repeal that. Like, they haven't done that. So that's what we have. And I hope that sort of addresses the question.
You certainly have answered my primary question, which was the first question. I understand your position that it should sort of be a 60. Anything above 60, there has to be more of a showing by the trial court. And I understand that's your position. I thank you for answering my questions. I notice my colleagues have their hands up. I'm going to yield back to the chief. Thank you, Chief.
Thank you, Justice Kahn. Justice Ecker.
Thank you. Good morning, counsel. So this case didn't go through the did this case go through the appellate court?
Yes.
All right. There's an appellate decision, and then we granted cert. Is that right?
Yeah. Correct. Yes.
I mean, it's an odd case. I remember now. I read the appellate court decision, but it's an odd case because it falls into that gap this sort of follows up on what Justice Keller was asking, and maybe what Justice Kahn was asking a little too. It falls in that gap of, basically, if we knew then what we know now, your client wouldn't have been entitled to a resentencing, right? Under Delgado and McLeese and so forth.
Yeah, so if we were in a situation where the legislature had done nothing but impose a parole opportunity, I don't think there would be a claim. But we're here because of the capital felony, which no longer exists after 1584, which abolished that for juveniles. He needed to be resentenced because he had the capital felony, and that's how we got here.
So he needed to be resentenced because of that. Okay, right. I think putting aside Justice Keller, I guess what I'm getting at is this: I wonder if we're working really hard here to construe a statute that may not be applicable except for in the future, except for going forward because of its effective date. But your position is that this statute applies, and no one has raised the point that Justice Keller raised, right?
And I hate to say that, but it sort of had never, I don't think, occurred to any of the parties along the way that might not apply. And I would like to look at it kind of maybe some sort of supplemental brief or something. That issue is not on my for this.
Let me ask you this: whether or not the statute applies, your position is that Miller applies, right?
So
or not, because a lot of people I think the state's position is, and I'll be interested to hear, that Miller sort of disappears now that parole is available. And now that there's parole eligibility, Miller disappears. And we said that, I believe in McLeese, as a matter of remedial law, that is as a matter of habeas law. I'm not sure, and maybe we did say it as a matter of general law, but that was a different case because resentencing there wasn't required. Here, it is required. And so my question fundamentally is, whether there's a constitutional undercurrent or shadow or something, or is it just purely a statutory question?
May I maybe borrow from my rebuttal time to answer this, because I think it's an important question. I know that I'm running short on time.
You may, counsel.
I apologize. It's a long question, too.
Yes. So I think it's an important question. And I think to start with, the clear answer is there isn't a constitutional claim directly raised in this appeal. This is strictly 5491G, what it means, or A2, what it means. However, I think that there is a constitutional context to this in that the legislature, after Riley, sort of had strong instructions from this court about what it must do to sort of fix the discretionary sentencing scheme in Connecticut for juveniles. And I think we have to look at it through that lens. We also see the language in A1 and A2, I think closely follows what this court said in Riley about Miller. You'll find, very similar language there. But directly, this is not an Eighth Amendment challenge as far as directly goes. So hopefully that sort of answers. And thank you.
Thank you, counsel.
Counsel, you'll have 7.5 minutes.
Thank you.
Attorney Miller.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. My name is Jennifer Miller. I'm an assistant state's attorney, and I represent the state of Connecticut in this matter. Unhappy with the outcome of his resentencing, the defendant now implores this court to construe 5491G in a manner that ignores the statutory text in order to compel the trial court to further reduce his sentence for his involvement in the callous murder of Kyle Holden. This court should reject that effort because it is not grounded in the law. The plain and unambiguous language of General Statutes 54-91G defines the sentencing court's obligation, that is, to consider certain evidence in fashioning its sentence and consider how that evidence counsels against a lengthy term of incarceration. That is the extent of the statutory requirement, and it was clearly satisfied here.
Justice Keller, then Justice Kahn.
I want your reaction to my question about how does the statute even apply to him? He was never a juvenile. Throughout the briefs, everyone's referring to him as a juvenile at the time he committed this crime. Raise the age went into effect in 2010 and not fully into effect for 17-year-olds until 2012. He was always an adult. So how does the statute even apply? If the legislature wanted, they knew how to make the changes apply to anybody under 18 at the time they committed the crime, because that's what they did with the parole statute. But they didn't do it in this statute. And I think we're going against the clear intent of the legislature. This was enacted for persons who may have been transferred. And sure, there were kids back in the 90s who were transferred because they committed their murders or A and B felonies when they were 13 or 14 and 15. But that didn't happen to 16 and 17-year-olds. They were adults. They went right to adult court. They didn't even pass go. So what's your reaction to my question about that?
I think that's a really interesting point, Your Honor. And as Attorney Brown mentioned, we didn't obviously brief that issue. I think the problem we run into here is that the parties agreed to this resentencing below, and I believe the trial judge was intending to implement the statute when it considered the factors. So it kind of puts us in a difficult position insofar as the court was clearly applying 5491G and considering those statutory factors in determining an appropriate resentencing. So again, we didn't obviously brief that. I'm more than open to a supplemental brief on the matter. I think it does raise an interesting point that no one really considered that preliminary clause. But because it was handled that way below, I'm a little uncomfortable at this juncture walking away from it because it is what the trial court applied in resentencing the defendant here.
Well, maybe it just took somebody who was doing juvenile law in the 90s to notice it. Let me ask you this. How do we know that he's going to get a parole hearing within 30 years when he's serving a consecutive sentence? That takes him beyond lifetime before that 30 years runs in the second sentence. Because he's got something like 70 years in the New Britain case, and then he's got another 70 years on this one. So the way I'm looking at it, he's going to be over 100 years old unless, I mean, is it true that the DOC or the parole board is just considering, let's say you murdered 3 people and got 3 consecutive 60-year sentences, okay? Despite that, you're going to get a parole hearing within the first 30 years, after 30 years? Is that how it works?
I'm sorry.
Go ahead.
I'm not entirely certain, Your Honor. I do believe that Attorney Brown is correct that they are looking at the total sentence and anything that exceeds that 50 years.
Under what authority? Is that
I
what
don't
they
know, Your Honor. I'm sorry?
I'm just wondering under what authority do they get to ignore the fact that there's that when they bring him up for parole, he's got a consecutive sentence over his head.
Again, I think that's a really interesting point. I'm not sure how it plays with the Board of Pardons and Paroles. I'm not sure how they handle. And yes, indeed, it is a consecutive. He has a total effective sentence of 165 years for his involvement in both of the crimes.
Right.
Yes. But I candidly, Your Honor, I am not certain. I was under the same impression that Attorney Brown was, that he would be eligible for parole in less than 10 years from now.
Because I think that they really shouldn't be considering consecutive sentences. I think they have to consider concurrent in order to give him that 30-year eligibility. But I don't know. We'll have to look into it. I just don't understand that.
Well, Your Honor, I would submit that.
Thank you. Go ahead.
I would just submit that requiring the trial court here to modify the sentence to a concurrent sentence would probably not be appropriate either, because the court determined in its judgment, after considering all the information before it, that his sentence should be indeed modified and decreased, but that it should still run consecutive in light of the nature of the conduct.
Now, let's say he goes up for parole. I think he'd be eligible for a hearing in like 2026. That's not far from now. If they deny him parole, he's done. He can never get another chance at parole. 30 years. He doesn't get any more chances at it. So he's got to serve out the 165. Correct?
I'm not entirely sure. I believe there is another opportunity for a parole hearing, Your Honor. I don't believe it's a one and done situation, but I may be incorrect.
Well, he's not going to get another opportunity under this statute, correct?
I'm not certain. I don't want to misrepresent, but I believe that if I look at the other cases of the juvenile offenders, when they have been denied parole, I'm thinking of Mr. Sims in particular, I believe they're given a subsequent opportunity to appear before the parole board. I'm not certain, but I do believe that is the case.
All right, thank you.
Thank you. Thank you, Chief. Attorney Miller, I want to ask just a follow-up question to this very interesting issue that Justice Keller raised. In this particular case, because each sentence for each file was over 50 years, presumably he'd be entitled to a parole hearing because it meets that statutory, over 50 years. The problem might be if somebody were to get, say, 3 separate cases and they have a sentence of 30 years in each running consecutive. Now you're looking at 90 years, and I'm not great in math, but my point being that you have 30, 30, and 30 running consecutive, so you're not eligible for a parole hearing in any one of the individual cases. So you'd have to look at it collectively. But in this particular case, as long as each file he received a sentence of over 50 years, presumably he'd be, I don't know how that works, if he'd be entitled to a joint parole hearing or a parole hearing in each case. Do you see what I mean?
Yes.
So it may not be an issue for this defendant, but I think the point that Justice Keller raises is an excellent point, which is, what about the defendant that receives sentences under 50 years that are run consecutive? Do you see what I mean?
Yes, Your Honor. Yes, and again, I would submit based on the information I have, that in that case, it would be the total effective sentence. I'm presuming you're talking about one case where it's 3. I mean, I guess that's kind of maybe where the differentiation comes in. If we're talking about one matter,
maybe that's the issue. I'm talking about 2 hypotheticals. One where you have 3 charges in one case, consecutive sentences for each conviction, each under 50 years, the total effective is over 50 years. I think there it may be less of an issue, right? It may be that the DOC or the parole board looks at the total effective sentence, right? But
right.
What I'm talking about is the situation in this case where you have 2 separate, if you will, files, 2 separate incidents, or 2 separate, totally separate, distinct offenses by date, or you have 2 jurisdictions where the defendant receives a sentence of under a total effective sentence of under 30 years in one jurisdiction, another to run consecutive, and a third, and it's 90 years, but none of them independently or individually are over 50. That's kind of the hypothetical I was throwing, which is different from this case.
Sure.
And I understand this issue didn't come up, so I guess I'm throwing a wrinkle in the hypothetical. Would that make a difference? But my primary question here is, in this case, because he received more than 50 years in each separate case, would he have been eligible for a parole hearing? I don't know. If it's consecutive, he doesn't start to serve it. I don't know. Is he eligible for a parole hearing, even though he hasn't started to serve?
I'm not sure, Your Honor, but I would say that candidly, if it ended up being 60 years that he had to wait in order to have a parole hearing, that would seem to run contrary to the purpose of the statute. So that would be the reason why I would think that they would look at the totality of the sentence. Here, they're both over 50 years, so he wouldn't be eligible until 30 years.
Okay. So let me ask you the final question, and I notice both Justice Ecker and the Chief have their hands up. So this is you heard my question to your opposing counsel. What is adequate consideration? And his suggestion was any sentence of 60 years or less is adequate. If it's over 60 years, the court has to explain why it considered but decided to go above that for some almost sounds like a federal, I'm thinking back to my federal days, an enhancement, an upward departure, if you will, argument. What's your position on that? What is adequate consideration, and your response to his response to my question? And then I'm done. Thank you.
My response would be that is not based on the statutory text at all, Your Honor. The defendant and the state both agree that the language is clear and unambiguous. And if that's the case, there's absolutely no legal basis to claim that there is a 60-year standard or there's some kind of upward departure requirement or presumption in the statute, simply unsupported by the plain language. And I believe he's even reading, and if I may, Your Honor, for a moment, the word adequate in. All it says is the court shall consider. So to me, that means the court needs to use it as guidance, be aware of it, consider the plain language of what that word means. And I think very clearly in this particular case, that was done. The court set forth all of the different factors, evaluated different factors, as well as this specific defendant. And so, yes, as the defendant himself noted, the court had to sort between those individuals who deserve harsh sentences and those that don't. The court did just that here and determined that this defendant did indeed deserve a harsh sentence for the crimes that he committed. So that's my answer, Your Honor.
Thank you. Thank you for responding to that. I also neglected to note Justice Doria has his hand up too. I'm yielding back to the Chief. Thank you, Chief.
Thank you. Justice Ecker, Justice Daria, and then myself.
I've asked some questions before, and I think I'm satisfied. If there's time at the end, I'll ask, but why don't you two go first?
Thank you, Justice Ecker. Justice Daria.
Well, Attorney Miller, I'll pick you up right there. Can you sort of tell me how you think that Judge Dewey considered the factors, and specifically about the scientific, evidence?
Yes, Your Honor. So she did go through, and I have the decision in full in my brief. She goes through and she discusses the Steinberg articles. She talks specifically about juvenile brain development and how juveniles engage in risk-taking behavior, but notes that the risk-taking behavior that the court read about in those articles and the scientific data did not include murder. So the court did consider that. Reviewed the scholarly articles, and I believe that the court began by noting that it reviewed all of the information before it that had been presented to it. And there's on page 11 of the state's brief, it goes through that the court had looked at the entire trial file, pre-sentence investigation, Dr. Lovejoy's neuropsychological examination, biosocial reports, and multiple scholarly materials. So the court.
So I guess that's my problem, is that she seemed to be. I think I'm never good at labeling what the logical fallacies are, but this might be a false dichotomy where she says, well, the articles I'm reading don't concern murder. Well, but certainly all of the cases that we're dealing with do concern murder. It's not the case that there isn't an impulsiveness question that could be considered as to certain, maybe these kids aren't juveniles, Judge Keller has suggested, but youths. And so while it may be true that, some kids are very well behaved and their brains aren't formed, they're also not all doing 50, 60, 70-year sentences. So I guess I wish there were a little better concrete example of how she considered them, other than acknowledging that there is literature about the incomplete brain and impulsiveness, but we're not talking about these kids. I always thought we were talking about these kids in juvenile sentencing cases, or at least the data the science has to be grappled with. Am I wrong about that?
No, and I believe she did grapple with it, Your Honor, because she knows that she reads these articles and they talk about certain risk-taking behavior. And this is on page 12 of the state's brief. Self-absorption, privacy issues, mood swings, unique dress, escapism, impulsive, risky behaviors such as drugs and sex. And what she's saying is that is what the scientific evidence bears out regarding juveniles. That's the kind of risk-taking behavior that they're engaging in. That does not include the criminal, reckless, callous behavior the defendant engaged in this case, murder, robbery. So that, I think, was her point. She was trying to explain that the articles about juveniles and their brain development, the general articles she read about adolescent brain development, and the information Dr. Lovejoy provided was not applicable to what the defendant did here. And again, Your Honor, I appreciate that perhaps in your estimation, she could have provided more information than she did, but that's not the standard that this court uses to review the sentencing court's decision. It's an abuse of discretion standard. So did the court abuse its discretion in sentencing the defendant in the manner that it did? And I would submit no. The court clearly complied with the statute and considered that information, and maybe didn't lay out every example, but noted that it reviewed all of the scholarly material before it and simply gave an example of how that scholarly information simply was inapplicable to this particular defendant.
Okay, thanks.
Thank you, Your Honor.
Counsel, I think Justice Doria's question actually covered just about all of what I was going to ask about. But I also noticed one other thing that Judge Dewey covered, which was not only the alpha of this young man's life, but the sort of the omega, what he was like currently. Can you tell me about that part of it?
Yes, Your Honor. So in determining that a lengthy sentence was appropriate for the defendant here, the court not only reviewed some of the positive aspects of his childhood as well as the negative ones, but it considered the fact that even as an adult with a fully developed brain, he was continuing to commit crimes in prison. He had 24 disciplinary tickets over a 16-year period, and those included bringing heroin into the institution. And also, even given the opportunity at his new PSI to take responsibility for his involvement in the crime, he continued to do what his own expert described as an externalization of blame. So continued even at the age he was, and I believe he was in his early 30s at that point, late 20s, early 30s, somewhere around there, continued to place blame on others and not take full responsibility for his involvement in the crime. So it wasn't just that his conduct at that time as a child, as when he was younger, or the brain development didn't support or supported or didn't support the sentence. The court looked at the defendant, this specific defendant, in his totality in issuing its ultimate sentence.
Thank you, counsel. Justice Keller?
Thank you, Chief. What's missing from this sentencing hearing to me is his early childhood life, which I understand was pretty bad. And maybe by the time he was 9 or 10, he was, I don't know whether he was with family or a good foster home or whatever, but the science is, the wrong science is being applied here. It's not the typical adolescent brain. When you have a child who's been neglected or abused early on in life, that's totally different science. And what happens to a child who's maltreated is very different from what happens to a child who's lucky enough to be raised in a loving family and might still have an adolescent brain that's prone to risk. But something far more malevolent is going on with many of our children. Unfortunately, I believe you don't hear a lot about it because the courts are closed and silenced and nothing gets publicized. How much did she look at his DCF file? Did she know what had happened to him when he was very young, to the point where he was removed and placed in a foster home?
I believe, Your Honor, that she did. She does note, it's on page 13 of the state's brief, that by all accounts he had a difficult childhood, which she noted.
How difficult?
She doesn't go into.
She really know how difficult his childhood was.
I believe she did have information regarding his childhood. I can't say specifically, Your Honor. I know that she had the new PSI. PSI typically contains that information. But she also notes that, yes, he had a difficult upbringing, but then he had a change of circumstances. And from the time that he was about
I know, but
8 or
it's
9
too
years-
late. That's the science. It's too late. The bad things that happen to their minds that make them more impulsive than the average teenager, less empathetic than the average teenager, is what happens to them in early childhood, before they're even a year old. And you know, if you're talking about how it got better for him when he was 10, too late, way too late. And no one looks at that. No one thinks about that. And that's the science the judges need to know. That's the science the judges need to know. That we're not doing enough to save them when they're very young. And when you try to save them and when they're 12 or 13 or 14, it's way too late.
I would just respond, Your Honor, and say that the court clearly considered his upbringing, but in light of the totality of the information,
You could call it that.
I'm sorry?
You could call it an upbringing if he has to be removed.
Your Honor, but that does not excuse his behavior entirely.
But it does in a sense, and that's what's missing here. That's the piece that's missing here.
I would respectfully disagree, Your Honor, only insofar as this court reviews, again, the sentencing court's decision for abuse of discretion, that this court would have weighed certain information differently, or that this court would have found that certain information should have had a reduced sentence even further. It should be noted the defendant's sentence was far more severe initially, and there was a reduction.
Right.
So the court did mitigate and did consider certain evidence as mitigating, but other information was not mitigating. So I think that means it's not just about this particular defendant, it's about this defendant as he's grown up, this defendant as he's continued to conduct himself, and the crime here. We can't lose sight of the fact that part of the consideration here is the crime. And the crime here was callous, and it was depraved, and the defendant committed another one 4 days later where he was the shooter. That has to be considered by the court in weighing what an appropriate sentence is. And the defendant here, I would submit, will only be happy with a sentence wherein he's parole eligible before 30 years. And the court did not find that was appropriate. So under those circumstances, although the court didn't consider, perhaps in this court's estimation, that his childhood sufficiently, the record doesn't support that it didn't consider it. And therefore, I would submit that it looked at the totality of the information, and on this court standard of review, it should determine that the court properly sentenced the defendant here.
Well, I guess what I'm getting at is this statute doesn't require, this requires that you look at the science of adolescent brain development, but I don't think it requires that the court go far enough with many of these young people. That's all the point I was trying to make.
Yes,
thank you.
And I tend to agree. I believe also, and I may be incorrect, I was trying to review the legislative history, and it's lengthy. And I believe that information is provided to the court for its consideration, the scientific evidence. I believe some of it is provided by the Judicial Department or the Probation Department. I may be incorrect, but they are getting that information, at least some of it, I believe, from a third party in making that determination. And again, perhaps the thumb may need to go on the scale in certain cases for the child's upbringing or the defendant's upbringing, but I would submit here the thumb went in the appropriate direction. There was mitigation, but ultimately a lengthy sentence was appropriate for this defendant. And I would, I'm sorry.
No, counsel, finish your thought.
Oh, I would just submit that with regard to the incorrigibility finding, the court properly determined that it could not find him to be incorrigible because the law does not allow it to. Under the law, an incorrigibility finding is only required or necessary where the court is going to sentence the defendant to life without parole. That type of sentence is no longer available for a juvenile defendant. So thank you, Your Honor. So in this case, that was a proper recitation of the law as it exists. And I'm a bit confused because the defendant appears to agree with that proposition in his reply brief. I'm sorry. Thank you.
Any further questions, Justice Keller? Justice Eckert, then Justice McDonald.
No, thank you.
Well, I think we're in a tough situation here because, you know, there's a very important underlying question, right, which is the one that the parties briefed, which is how to read 5491G and the consider language. Does consider have real teeth to it, or is it sort of a like in divorce cases, I've considered the statutory factors kind of thing. And those are really interesting, difficult questions. The problem is that the questions that we're spending most of our time on and hung up on are these questions that haven't even been briefed. The two raised by Justice Keller. I'm not, blaming anybody. I missed them as well, really, frankly. But, it is a problem. And even with respect to the, if you ignore whether 5491G applies at all, the question of how sentences, when they're especially not in the same case, how they fit together for parole purposes, depending on how we answer those questions, we may never get to the 5491G issue, I suppose. So I'm wondering what is additional briefing. I guess it's our decision, but should we have additional briefing? There have to be cases out there on how Miller and Graham in those cases apply in the where there's multiple sentences or different sentences. Because if Justice Keller's right and he's never eligible for parole, then I would think it is an unconstitutional sentence because he's gotten a life sentence with no possibility of parole. Or does Miller and Graham not apply? I just don't know. But I mean, are there answers out there to these questions, or don't you know as you stand there?
Your Honor, well, first I would say Miller and Graham do not apply here because there's no constitutional issue. Montgomery resolved any Eighth Amendment claim. So this is purely as the defendant.
But that's only if he's parole eligible.
Correct. He is absolutely parole eligible. I think the query is when, and I would submit that I'm not sure, to be candid, what supplemental briefing will provide unless Attorney Brown and I reached out to the Board of Pardons and Paroles, because I believe they are the ones that make those determinations. So I'm not sure that we will necessarily be able to find a case that will elucidate that for us. I'm certainly obviously more than amenable to doing so or attempting to do so. But again, I think that Attorney Brown is correct that it looks at the overall sentence, and because it exceeded 50 years, he would be eligible after 30 years. I don't think Attorney Brown would dispute that, and in that sense, he's eligible for parole in less than a decade.
Counsel, I just want to step in here for a second. Justice McDonald, could you please stop the time for a second? And the reason why I'm stopping time, because this is a really unusual situation that I have here. And I'm going to talk with the justices in conference about how we can possibly resolve it in a way that gives us the best judicial economy and is fairest to the parties, as well as those people out there in the who may have the situation who aren't involved in this particular court matter. So I've got some serious things to talk about with the other justices about how we're going to resolve this issue. And I'm sure that we'll get back to you about that, whether it's further briefing or whether we don't take further briefing. But I didn't want to use counsel's time to mention that. I just wanted to tell the rest of the court and to the attorneys what I'm thinking about it. Thank you, Justice McDonald.
And thank you. You've answered my question, counsel. Maybe it was an unfair set of questions because I think, as the chief said, it may be ultimately court decisions about how to handle a case like this. I appreciate your input, though, and I yield to whoever's in line.
Thank you, Your Honor.
Justice McDonald.
Thank you, Chief. Well, you have 30 seconds left, but my question, I'll try and make it quick. You said that the sentence on resentencing was dramatically reduced. I mean, let's be honest. It was a 80-year sentence, and it was imposed consecutively. And the trial court specifically says on page 83 of the sentencing transcript that the total effective sentence is now 165 years. So the court contemplated that it would be 165 years in two separate files. And I've yet to hear what the authority would be to aggregate separate convictions for purposes of determining parole eligibility. They are two separate sentences. You're eligible for parole on a sentence. And so in my way of thinking, the first sentence would have to be after 30 years of time served on the 85-year sentence. If you got parole on that somehow, he would then get another 30 years of prison time on the second conviction. And I respect the fact that neither counsel saw this issue. It jumped off the page at me. It was so obvious that it's a serious problem in this case. So I know that you didn't raise it, but or neither party did. But that's what I'm struggling with most here, because if that is true, then he has to serve 60 years before he would be eligible for possible parole, and that brings it right back into a life sentence.
Your Honor, and that's why I believe I noted before that I think that would not align with the spirit of the statute. So I think, candidly, Your Honor, I think that a decision from this court saying that sentences must run concurrently would seem to abrogate the trial court's sentencing authority. So perhaps what both Attorney Brown and I have suggested, that the appropriate circumstance is that it be either left to the Board of Pardons and Paroles, or this court simply indicate that the total sentence should be considered as over 50 years, and therefore the defendant would be eligible after 30 years, is the most appropriate way to handle it. I suspect that Mr. Coulthurst probably is not the first case where this has come up. I can't definitively say, Your Honor. There obviously have been a lot of juvenile cases that have gone before had parole hearings. But I would submit that by judicial fiat, this court should not take away the trial court's authority to sentence consecutively in juvenile cases. There's simply no law to support doing that, and it would seem to be an overreach of 5491G and really the spirit of sentencing in general. So perhaps the best solution is that which both Attorney Brown and I have suggested, which is either leaving it to the Board of Pardons and Paroles, or noting that the best way to handle this is looking at the aggregate sentence or the entire sentence cumulatively of the two.
Okay, my final question is, you said that the facts of this case with respect to this particular defendant were particularly callous and depraved. What was the conduct that, in the state's view, was so callous and depraved on this defendant? I mean, he didn't shoot the victim, did he?
No, he did not, Your Honor. But this was a planned. I'm sorry, Your Honor.
Well, no, I understood the facts, and I could have them wrong, but I understood the facts that there was a plan to do a carjacking. And so I'm just trying to figure out, if is, in the state's view, are all carjackings particularly callous and depraved by their very nature?
No, Your Honor. I believe the fact that they were going around looking for somebody's car to take, they took this defendant's car. If I have the facts correct, Your Honor, of course, I've looked at a million other things getting ready for this argument. I believe they then went to the ATM, took the defendant's money, the victim's money, excuse me. The defendant and the cohort then drove around a bit. The cohort executed this victim. This was not simply a shooting. He removed him from the vehicle and executed him and then left him on the side of the road. And the defendant and the cohort then drove around the area, as the trial judge noted, knowing that his body lay in that ravine. And then when they wanted a new car 4 days later, engaged in the exact same conduct, but this victim survived. So I think the court is looking at the defendant in his totality. In that case, the defendant was the shooter. And yes, I believe that carjacking somebody who was simply minding their own business, taking their car, and then murdering them and leaving their body on the side of the highway and driving around in that vehicle for days afterwards until they ditched that vehicle for another one is absolutely callous and depraved, even if he was not the triggerman.
I appreciate that answer. I'm trying to isolate the facts for this defendant versus his cohort in considering that argument, but I appreciate your answer. Thank you.
Thank you, Your Honor. Your Honor, obviously my time is up. I would just ask this court to affirm the appellate court's unanimous decision here. Thank you.
Thank you. I see there is a question from Justice Keller.
Oh.
Attorney Miller, you say we should leave it to the Board of Pardons and Parole. I have a problem with that because I believe that, just as Justice McDonald just said, there may not be any basis to give him parole on the first sentence, the New Britain sentence, when there's a sentence to be served consecutively. And that's what I'm worried about. And when the Board of Pardon and Parole is aware that the court ordered consecutive sentences, isn't that going to affect their reaction to giving somebody parole?
And maybe it isn't, and perhaps maybe it should, Your Honor. And I think that goes to my point about why this court, I believe it would be improper for this court to order that only concurrent sentences would be appropriate when there are two completely different crimes in two completely different jurisdictions. That does not seem, it seems like to be taking over the trial court's role. So perhaps
but then, you know, if Justice McDonald is right, then you're effectively violating the law by basically sentencing him to life without parole.
As I noted, my second suggestion would be that this court could note that where there are consecutive sentences, in light of the spirit of the statute, that the defendant should be parole eligible after 30 years. The court,
we can't note that. I mean, we need to know what the law provides with respect to consecutive sentences in two totally different incidents.
Your Honor, then again, I guess I would go back to the state would request supplemental briefing.
I mean, they must be doing something now with other non-juvenile defendants who have consecutive sentences in two separate incidents in determining when they're going to be parole eligible. I mean, I don't think that would be that hard to find out.
Yes,
Okay.
and again, I will absolutely engage in supplemental briefing on this question. Thank you.
Thank you.
Thank you very much. My apologies to both counsels for going over the time limits, but I appreciate your patience and cooperation. With that, we will be in...
Chief, there's the rebuttal.
Sorry about that. You're right, counsel. You're right, counsel. You're right, Justice McDonald, and welcome to your new job of attorney. Attorney Brown.
So I want to jump quickly. I have a list of things here, but I do think that under 53A 38B, there is a discussion of consecutive sentences being aggregated. And I also think under 54 125AF, there is a discussion of crime or crimes committed by juveniles. And there's a contemplation of, and I can at least, whether that's right or wrong, I can say that's why that issue wasn't raised. I think there was an understanding that that's what parole is doing and that was correct. But I think that's my understanding of the statute with that. And getting to, and I think we're going to probably need briefing on this, but I do think it's important that this resentencing happened by agreement and that the state did see the capital felony as being a retroactive thing and then the sentencing did occur after that date. I understand the transfer issue, but I think that that's kind of not necessarily clear on the record how this all evolved, but it was sort of by agreement and all those things. So I do think I want to say, based on what the state has said about what it means to consider, a question comes to mind about whether what the state's position would be if a trial court said, I'm aware of all this juvenile stuff, I don't like it, and has no bearing on my ultimate decision. Is that consideration? Is that enough under the state's view? I would have to say that it would seem consistent with their argument that would be the case. And going a bit to the Pinkerton issue in this case, which the trial court sort of harshly rejected. And I actually, as I was preparing for this argument, realized that I made a slight error in my briefing where I said he was found guilty by as an accessory. Actually, Pinkerton is vicarious liability, which is one more step, I think, attenuated. And if we look at the deliberations in this case, the jury actually struggled a lot with what it meant to be foreseeable in a crime, what it meant to whether it was what Jamal thought was foreseeable or whether what a reasonable person thought was foreseeable. Not to take that point too far, but I would assume the reasonable person standard would be a reasonable adult considering the consequences of a situation. And, you know, those arguments were sort of rejected by the trial court as far as the significance. And I know there's questions.
Thank you. Counsel, yes, Justice Ecker has a question.
Yep.
I'm going to add a few minutes to your time if you need it in the end in order to equal things out. Justice Ecker.
Thank you.
Counsel, I know you haven't raised a constitutional claim here. Hopefully this is a fair question anyway, but do you know if the Miller line of cases defines juvenile sort of as a federal matter, as a constitutional matter, or does it leave it to the states to define it so that if we say it's 18 and somebody else says it's 16, then the Miller-Graham regime only applies to the age as determined by the state?
I do believe that Miller, well, actually moving back, I believe it was Roper that drew the bright line at 18 and said there's issues with drawing a bright line, as there is in every case, but that's where they drew it. And then Roper, the evolution from Graham to Miller. So I do think 18, there isn't a choice about whether constitutionally that's a child or not.
And just to follow up on that, maybe this is where we switch from the constitutional to the statutory, I don't know. But my understanding, I haven't looked at it in a couple of years, frankly, but is that 5491G was intended to, we'll find in the legislative history, if we could get there, I suppose, is that it was intended to comply with Miller. Yes. Is that right? Okay. So that leaves some interesting questions opened. Of course, it was only intended to be applied prospectively, so it makes sense that it would refer to the then existing juvenile regime, I suppose.
Right, and I think that, sorry, just if.
Go ahead, I'm done, thanks.
Yeah, I think there is a very narrow class where this specific issue would come up. I know Riley also, was returned, I think his case was earlier, and that was never, we lost on the merits of what 5491G means. But I think other than Riley, Colthurst, I'm not aware of anyone else going back to be resentenced under 5491G because of the vacating of the capital felony. So this could be a class of one. But I think what 5491G is an important question, and I hope that we get to it in this case, but I guess there might be some briefing on that. And when talking about what 5491G, I think this question of abuse of discretion, I will say it seems to me in Connecticut, we've kind of gone down a road with abuse of discretion that it's essentially, I think the state frames it as if it's within the statutory framework, it's not an abuse of discretion. And I think there is a question under 5491G because of the constitutional issues that are encompassed of whether something more than just being within the statutory limits is appropriate. And I talk a little in the brief about maybe a heightened standard, or maybe it's just that the discretion is structured or limited under that abuse of discretion standard, which federal case law does sort of talk about what an abuse of discretion means in a more structured way than sometimes we talk about it here in Connecticut.
Anything further, Justice Secker? Justice Keller.
I'm done, thank you.
Thank you, Justice Secker.
Attorney Brown, I'm curious as to why you think 60 should be the sort of limited standard. Do you really want to say that? Because once you go over 50, they got to do the 30 years. So whether it's 60, 70, 80, 90, 100, I mean, let's not get into whether there's a consecutive sentence involved, but it's still going to be a 30-year parole. So wouldn't you really want to argue that taking into account and consideration of the adolescent science, you really should go below the 50 so that they have, less time to meet the parole requirement?
So my answer to Justice Kahn was a strictly kind of, I didn't mean it to be so specific as 60, but I think the reason why I said that was there is this language in the statute under A2 that I think should guide some of the analysis about under which it's likely the child will die in prison. And I would say we look at that sentence or that clause independent of the parole opportunity. But I would just say that and then what that sentence is, if it's 50, it kind of maybe becomes sort of a more actuarial or factual question, but I think it's guided by that likely to die in prison, and that's where my answer came from. And I think I also was trying to say that it's sort of an interesting question that I don't have a specific answer on. And I hope that helps a little bit saying that.
All right, thank you.
So I think that there's a couple things, and I want to get back to what Justice Keller said actually about the trauma and the things that had happened to Mr. Colthurst when he was a young child. And there was a mitigation report submitted to the court by Beth Cahill that did detail a lot of that, witnessing drug dealing, witnessing a homicide as a young child. There was an incident where Mr. Colthurst was not supposed to be outside of the house because he was grounded, and he was outside and witnessed a murder, and he couldn't tell his mom about it because he wasn't supposed to be outside. And there's some of these things that happened that I don't think it goes away because you move to the next town over, some of those things that happen when you're a child. And also to the externalization of blame concept that kind of came out in this case, and it returns a bit to the Pinkerton issue in this case when, I mean, Mr. Colthurst agreed to do a reckless, stupid, very dangerous crime. But I don't think back when this case was tried, anyone ever suggested that he planned to kill Mr. Holden. And unfortunately that happened. But for him to say, I didn't pull the trigger, but I'm still responsible and I understand that now, I don't know if that's an externalization of blame. And I think what Dr. Lovejoy was talking about with the externalization was him discussing how his upbringing and his environment may have contributed to the road he took, which I think is probably accurate. So, thank you.
Anything further, Justice Keller?
No, thank you. Thank you.
Thank you, Justice Keller. Justice Kahn.
Thank you, Chief. Counsel, my question is simple, though. In this case, the court could look at his behavior within that week period, not only in light of his role, whether or not he was the shooter with the first carjacking, but the subsequent carjacking, where he was the shooter. I mean, the courts can look at, you know, it's not just looking at his juvenile brain, it's looking at all of his conduct, his history, his early history, his critical, you know, as a child, you know, even more so than what he does when he's presumably old enough to have a curfew and not be outside of the house. But doesn't what happened 4 days later also inform to what extent he was part and parcel of the first incident?
I would agree that the other incident is relevant. Sentencing conduct, I would call it, that is something the court could consider. I still think, considering his role in this case, the trial court shouldn't have rejected that the way that it did, is, I guess, my answer. And I thank you all for indulging with the extra time. So
thank you, counsel.
Thank you, Attorney Brown. With that, we will conclude today's hearing. I'll see the justices in the virtual conference room right after. Thank you both, counsel. This is played out rather interesting today, so we have a lot to talk about, and counsel will hear from us one way or the other how we will try to resolve the issues that were raised. Thank you very much. I appreciate your patience. I appreciate your professionalism in the argument. Everybody take care. Be well. I'll see the justices in the virtual conference room.
thank you.
Thank you, Your Honor.